if you look at the flu this month, you're going to notice that one more time this year, where it says Wisconsin cases, there is a blank or a line that says no Wisconsin cases decided. Been doing flu for, I think it's on the 16th year now, and without going back and counting, I would guess that line, no Wisconsin cases this month, has probably been said in the first 12, 13 years I did it, maybe once or twice in that entire period of time. In the last couple of years, it seems to be creeping in more and more, and this is at least the second time this year there has not been a single Wisconsin case. Until we understand this, what I'm saying is that there is no Wisconsin Supreme Court case in family law, which isn't unusual. There is no Wisconsin Court of Appeals case recommended for publication, which isn't entirely unusual. And there is no Wisconsin Court of Appeals case which is authored that, even though it's not published, can be cited for its persuasive value, even if it's not precedential. In fact, if you look through all of the Court of Appeals cases during the month of May, you're not going to find a lot of even per curiam decisions in this field. So besides keeping track of the cases for flu, I also am in charge of a program on Wisconsin Case Update that we do 4 times now. I do with a panel of other, another lawyer and another judge. We do it for the Academy Wisconsin chapter. Internally, we do it for the Wisconsin chapter annual seminar. We do it for the Wisconsin Family Court judges, and we'll be doing it for the family law section of the state bar in Door County. And I'm beginning to wonder if, when we plan doing this case law update program, if I ought to say, gee, we're not going to need the full 2 hours that you're allocating to us, because there just aren't that many cases out there. And this is a trend that has gotten extremely noticeable, and if there's anything that's changed significantly in the years I've been doing family law practice, it is the fact that cases are being settled and not litigated that would not have been the case many, many years ago. In fact, I was hired by this law firm out of the DA's office because Leonard Loeb wanted someone to come in and handle his litigation practice. Leonard was an outstanding negotiator, and he far preferred to settle cases than litigate them, and he was way ahead of his time in terms of promoting settlement, and he wanted somebody who didn't have to train as a trial lawyer, so he found somebody in the DA's office, happened to be me, and my job was to come in and handle litigation practice. And I was in court constantly. I was at probably trying 4 to 6 divorce cases a year in terms of full, complete trials, not to mention the family court commissioner's office, constantly handling hearings, depositions, motions, and, as I said, full and complete trials. That has changed very significantly. I can basically throw out the phone number of the family court commissioner's office. It's so rare we do first hearings up there anymore. The depositions are a rarity in this field of practice. We've gotten to the point where we're exchanging financial information on a voluntary basis. And litigation, I probably average 1 trial a year now, where I used to be trying, as I say, 4 to 6 trials per year on average. What's caused that change? Why has the flu portion regarding Wisconsin cases, the case update program, gotten so much shorter over the years? And I think there's several reasons. One primary reason, I think, is that there's been a cultural change, where litigation used to be more accepted in a general societal basis. It's now become more accepted to resolve and settle cases. That reflects itself not just in family law, of course, but also in other areas of law, such as personal injury, where I think those lawyers, I would agree, I've talked to any number of them, that far more cases are settled today than were litigated in years past. And there's sort of a societal recognition, I think, to a large extent, that the costs and risks of litigation are best offset by reaching some sort of a compromise in settlement. And I think that's the primary reason. It is a societal belief against litigation, more in favor of resolution. coming from that, in other words, we start with that as the primary basis, and then flowing from that is the use of mediation, which has become far more widespread. I spoke about that in a previous video about the fact that I recently received training as a mediator, and I've found any number of mediation sessions that started with, hey, we'll never resolve this, and ended a full settlement to be because of the mediator. I just did a full-day mediation session as a mediator where parties were several $1 million apart, and by 5:15 p.m., we had a 5 p.m. cutoff. We were a few minutes late. By 5:15, we were all sitting around and summarizing the agreement we had reached, and parties got divorced a couple weeks later based upon that. And mediation has that degree of success that makes lawyers and courts now want to do it. Courts require it, and many lawyers in this firm, we will offer mediation if it isn't court ordered. In every case before we go to trial, offer the other side an opportunity to go to mediation in terms of resolving the case. And that's been a major change, but I think that flows from the societal change in favor of resolution and away from, as I said, the risks and costs of litigation. I'm not sure where this leads us. I'm not sure if we've reached the point where trials will become something that never happen anymore. If this is a matter where we'll reach the point where we are, where there will always be a certain number of cases litigated, and but most cases will be resolved, or if we move toward the point where that ratio will even change more in its favor, we may even move backwards. If I had to guess, my guess would be that there's always going to be a small, limited number of cases that are litigated, but they'll be very small and even a little bit smaller than today, but it'll be a rarity, and that the skill in practicing this area of law will be not just in resolving cases, but in resolving cases better for our clients. It's one thing to get to a resolution. It's another to get to a resolution in a way that saves both the emotional and financial costs for our clients. I mentioned Leonard Loeb earlier as an outstanding negotiator. The mantra in our office, Leonard said this many, many times, is that the goal of a family law attorney is to reach a resolution that's in our client's best interests without adding to or creating the degree of animosity that would prevent the parties from walking down the aisle together at their children's weddings. Earlier in his life, Leonard said, and sometimes is quoted by some people as saying, without creating or adding to the degree of animosity that would prevent the parties from dancing together at their children's weddings. Later in life, Leonard said, you know, it's too much to ask them to dance together. If they could just walk down the aisle together, that's enough. Interestingly, that philosophy is conducive with better financial results for our clients. If we can handle divorces in a methodology that is consistent with allowing the parties to at least walk down the aisle together at their children's weddings, it encourages people to maximize their earnings, and that gets shared in the form of either child support or maintenance. How do we do this? Well, there are a number of ways lawyers can help their clients in terms of furthering that goal, which helps them, as I said, they're going to reach a better result in most cases at the end of the case, plus preserving their relationship for the sake of their family, and children, and their grandchildren. For one thing, let me be a little self-promotive. I wrote a book, but was published a little over a year ago by the ABA Family Law section called Settlement Techniques in Family Law, where I describe a number of different areas of settlement in terms of not just mediation. I discuss a little bit of collaborative divorce, a little bit of cooperative divorce, and I go into some areas such as game theory and other areas and techniques of settlement. And if you go to the ABA Family Law section website, you'll be able to find a link to that book. I'd like to buy it, I'd be pleased to autograph it for you. DCI, the Divorce Cooperation Institute, offers a seminar every year. It's the first Friday in November, and we'll be doing it again this year. And we bring in a speaker who isn't your normal speaker coming in to talk about evidentiary issues in family law. I mean, after all, if we're settling 90% of these cases, why do you want to attend a seminar in how to litigate a case if that's less than 5% of your practice? Wouldn't it make more sense to listen to a speaker who talks about what we do 95% of the time? This year's speaker is going to be a psychologist who is going to speak about the psychological effects of stress and the other factors that go into helping us represent clients, understanding what they're going through, and getting them, to use the term in the famous book by Fisher and Urey, to get them to yes. But not just to get them to yes, period, but to get them there in a way which minimizes the destructive effects of divorce. That seminar information can be found on the DCI website, which is divorcecooperationinstitute.org, or just search for Divorce Cooperation Institute, and the information about that seminar will be there. And since I threw in a self-promotion about my book, I'm throw another one about mediation. The choice of mediator is really important in this. And I've had cases that it just hasn't been the right mediator for the type of people or for the nature of the case. Some cases, a reserve judge really is the best mediator who can come in and say, hey, if I was on the bench, this is what I would have done. In other cases, it's a lawyer who has represented clients and knows what they're going through. Some lawyers are better at certain issues other than others. Other lawyers are at other issues. So be careful in the choice of mediators, but a good mediator can resolve the vast majority of these cases. So the bottom line in this thing is that another month of flu is going to go by with that notation. No Wisconsin cases to be cited this month. I think that's going to happen more often as we go down the line, and I don't think that's a bad thing. But I think as lawyers, that trend is something we need to recognize, we need to work with, and we can do that in a way to make our representation better for our clients in their future.